Hello, my name is Michael Massman. I'm an attorney with Neighborhood Legal Services of Los Angeles County. And this presentation is about discovery, specifically the discovery process in a debt collection case in limited civil court in Los Angeles County. So let's talk about what discovery is, and I like to first place it within the context of the court case. So a case like this can be seen as having three big steps. The beginning step is the pleading stage. That starts when somebody files a complaint alleging that money is owed. That complaint is then served on the defendant, the debtor who is alleged to owe money. And that person has an opportunity to respond by putting in what's called an answer with the court. And those are the pleadings. Simply put, it's where each side stands. One side says you owe money. The other side might respond, no, I don't, or I do, but it's less, etc. In Los Angeles County, they generally schedule a trial for about a year after the case has been filed. And the trial is what happens if no settlement has been reached before then. And that's where a judge is going to listen to evidence and make a decision. In between the pleadings and the trial and judgment is what's called discovery. And that's the topic of this presentation. So what is discovery? Well, discovery is the exchange of information and evidence by the parties. Court is not supposed to be like it is on TV where there are surprise moments. The purpose of discovery is to allow each side to have reasonable access to the evidence that might be presented. And therefore, when it gets to the judge can make a decision based on evidence as opposed to trickery on one side. So some important things about discovery. If you receive discovery requests from the other side, and we'll talk a little bit about what you might receive in a bit, you have to respond. Not responding can cause you to lose the case. And similarly, you're allowed to ask the other side for information and evidence. And there are forms available that will both allow you to ask for evidence and to respond to the other side. And we'll have a little bit more information on how to find those forms at the end of this presentation. So types of discovery. There are generally three types of discovery that you're likely to encounter in a case like this. They're not the only types. For example, one that you often do not see is a deposition. That's where somebody asks you questions under penalty of perjury live, but here that generally does not happen. What you're likely to see is something in the mail. And so those can be three things. Interrogatories, those are simple open-ended questions. Document requests, which are requests for certain documents in your possession. And requests for admission, which are simple factual statements that you must admit or deny. We'll talk a little bit more about what those in a little bit, but important things in the process. Their discovery is exchanged between the parties. It's not filed at court. So you don't file your responses, you mail them to the other side. The only time the court might get involved is if there's a dispute as to whether or not somebody has to respond, as to whether or not a certain question or request is appropriate. As I said, there are forms and templates available. You have 30 days, generally speaking, to respond to discovery requests. If they were sent by mail, you get an extra 5 days, and that time is based on the date that they were mailed. An important thing about deadlines, though, don't wait until the last moment. As I said earlier, missing the deadline can result in serious consequences, including the loss of the case. If you want an extension, you can reach out to the side and ask for an extension. However, make sure that you memorialize that by an email stating the specific date to which your extension has been granted. So revisiting types of discovery. Here you see an example of interrogatories. There are both court forms, such as you can see on the screen on the left-hand side. And there are typed out questions as well. And you could get either one of those. And questions they might ask might be to verify the account number at issue, or to verify your address, or to ask if you ever disputed the charges, etc. There are requests for documents, which you generally see typed up, and things they might ask you for could include billing statements from the creditor, from the original creditor perhaps, if it's a debt buyer that's suing you. Any communications between you and the creditor, records of disputes about debts owed. Those are requests for documents, or sometimes called requests for production of documents. And then there's requests for admissions. As I said a little bit earlier, requests for admissions are simple declarative statements, factual statements that you either admit or deny, or say you don't have enough information to admit or deny. And the really tricky thing about requests for admissions is that if you don't respond on time, the other side can go to the court and ask them for an order that says you admitted what they've written. So they often write things like, admit that you owe $5,000 whatever on such and such account. If you do not respond in time, they get to court and they tell the judge you haven't responded, and they get that order saying that you've admitted those. Then they don't even, all they'll do at trial is submit that. And that'll be enough for them to win. So it's very important that you respond to these if you get them. Consequences. Like I said, you can lose the case in the way I just explained. They can ask the judge for an order deeming your request, your failure to respond to request for admission, as an admission. And that will be all they need to win the case. Additionally, if you don't respond, they can ask the other side for court fees, or for attorney's fees rather, in their efforts to compel your response. So it's very important to respond to these. Some important tips and pitfalls. When you read the questions, read them closely. Don't answer more than was asked. Only answer what was asked. Always be truthful, even if it seems the truth is bad for your case. You're responding to these under penalty of perjury. So you can't lie. Again, you don't file the responses with the court, you mail them to the other side. And you have to sign your responses under penalty of perjury. More about that on the forms to follow. Finally, you should make copies for your records. Mail them to the other side, but have a record of that for yourself. Help with discovery. So here are some great resources. The court's self-help website has great resources. You see it there. The Sacramento Law Library is an excellent go-to resource for templates for how to both ask for discovery requests and respond to them. They include the signature block at the bottom, which says you swear to this under penalty of perjury, which is responded. It's called verifying your discovery responses. Finally, the Los Angeles Library is also a very good resource. Some more information. Here's a link to our website, how to get in touch with us by phone, QR code. You're welcome to log on there for self-help resources and to fill out a self-help questionnaire if you have more questions. Thank you very much for your time. I hope this presentation has been helpful.